1010 WOLB Baltimore and WERQ FM HD3 Baltimore.
The views and opinions of the guest and host you hear are not necessarily those of the staff and management of Radio 1, its sponsors, or advertisers.
Welcome to the Our Legacy Matters show, where we'll discuss how to secure, maintain, and transfer wealth to future generations. I am your host, Attorney Sherry Fleming. Now let's tune in. Good morning. Good morning. Welcome to the Our Legacy Matters show. This is Sherry Fleming. And while I am an attorney licensed here in the great state of Maryland, I am not your attorney. So I encourage you to seek professional advice if you hear something today that you want more specific information about. So today we're going to deviate a little bit because I'm answering questions. And this question is estate planning related, but more specifically about real estate, a question that was sent in through our online system. And so the topic says who to contact to place a name on the deed, and a specific explanation of if someone remarries and desires to put their new spouse on a deed, how to go about doing that. And so to answer your question, in the state of Maryland, an attorney has to draft a deed. There has to be a certification. However, you can go through a law office or you can go through a title agency, which typically a lot of them are owned by attorneys or have an attorney on staff to make sure that the deed is drafted properly. And so, but more importantly, I want to talk about not just naming a new spouse on the deed, but I want to have a discussion about adding anyone to a deed. And so, just for clarity's sake, I use the term deed and the term title interchangeably, but so that everyone understands and everyone is on the same page, title is the term that we use to designate ownership. So if you are owner, you possess title to anything, to real estate, to personal property. When you own it, you possess title. A deed is a written document, which is paper, and it is evidence of your title. It is evidence and that you own the property you say you own. So like your birth certificate is evidence of your birth that occurred. It provides detail about your parents, where you were born, your weight and height, all of that good stuff. A deed is evidence of your ownership in real estate, evidence of your ownership or your title, and it contains the characteristics of the property as well as the type of ownership that you have. And so typically there are different types of ownership. And let me also be clear that if you are listening in another jurisdiction, some of this stuff is general and it may apply to you, but real estate is state specific, and even more state specific. Real estate is county specific, municipality specific. What is permitted, how things are transferred literally depends on where the real estate is located. Okay. So again, make sure that you're seeking professional advice in the jurisdiction that you're in with regard to the property in question. So there are some general types of ownership that I want to mention, because not all ownership of real estate is the same. So there may be a deed, and on the deed, again, expressing your title, the type of ownership that you have, it could list your name and another person's name. So the person who submitted the question, I happen to know, it is a female. She owns the property and it's just her name on the deed. And so if she adds a spouse to the deed, that ownership type can be tenancy by the entirety, is what it's called. And it is an ownership type that is specific to those individuals who are married under the law, and those individuals who want to express joint ownership in a property with right of survivorship. And so, it's a joint tenancy with right of survivorship. What does that mean? That means when one of the spouses expire, that the whole of the property, the entire property, passes to the remaining surviving spouse. And so tenancy by the entirety is an ownership type, a joint tenancy type, specifically for married individuals. Another type of ownership is joint tenancy. And joint tenancy with tenancy by the entireties, joint tenancy with right of survivorship, I already expressed. There are two people that own a property together. They both have a right and entitlement to the entire parcel of real estate. And when one person expires, the whole of the property goes to the surviving person or surviving persons. The difference between tenancy by the entirety and a regular joint tenancy with right of survivorship is simply marriage. With tenancy by the entirety, you have two spouses that are married. With joint tenancy with right of survivorship, you can have any two people owning a parcel of real estate together. So it could be mother and child, father and child. It could be a number of people. I don't want to limit it to two. You can have a number of people who own a property with a right of survivorship. I see this a lot with siblings. It may be 4 or 5 siblings. They all have a joint tenancy with right of survivorship. And as each sibling expires, the whole of the property goes to the remaining sibling until there is one left. And so that's how that works. Another type of ownership that is generally out there, is what we call tenants in common. And this is when multiple people own the real estate, but they do not own the entire parcel of real estate. They own a fractional interest in the real estate. And what that fractional interest is detailed in the real estate. So you can have 3 people who own a third, 2 people who own a half. You can have one person who owns 2/3 and another person who owns 1/3. And so it doesn't have to be equal. It's really what's specified in the deed. And again, that deed is evidence of title. So when someone comes to me with a real estate question, my first question, because I'm an attorney and we usually answer questions with questions to obtain more information. My first question is, how is the property owned? Again, tenancy by the entireties, joint tenancy, tenants in common. Then another characteristic of the real estate where we look at, well, what is the interest held in the real estate? Fee simple is when you own the totality of the land. And actually, this is when it comes to real estate, this is a topic we can have several discussions about. When you own real estate, there are different interests in real estate. You can own the ground. That's the dirt, the grass. You can own the improvement. That is the building that's built on top of the dirt. That improvement can be residential. It can be commercial. You can own some airspace above the improvement. Airspace right is a real estate right. Also, you can have subsurface rights, and that's a right to anything that's within the ground. And so think about oil, natural gas, diamonds, water, everything that's under the ground is considered a subsurface right. And so when we're having discussions about real estate, it's very important that you are not limiting your thinking to just the house or just the improvement. You should consider those things underneath the actual ground, those things above, and the air up until a certain point within airspace. And so when I say we need to look at the interest, that's the interest that a particular person has in a real estate, that is what I'm referring to. What exactly do they own? And so one interest is called fee simple. When someone owns real estate in fee simple, they own everything. They own the totality of the real estate. They own the ground, everything within it. They own the infrastructure on top of the ground, as well as a portion of the airspace above the ground. Okay. And for those of you who are thinking, what is airspace rights? Think about all of the issues that you may have seen in the news when drones became a thing, and people started using drones to look on top of people's homes, when appraisers use drones, or a contractor used a drone to look at a roof. Think about, if you remember the news a couple of years ago, all of the issues or some of the things that transpired as people began to use drones. The real controversy involved, or one of the controversies involved, was, do you have a right to hover over someone's property? Is it a privacy issue? Is it a real estate issue? Is it an aeronautics issue where you have that drones that may bump into some federal aviation laws? So when I want you to really think about more than just the house when we're thinking about real estate. And so again, fee simple, you own everything. In Maryland, we have what's called ground rent. Ground rent actually is in a couple of states, but is a bigger deal here in Maryland, where someone's house is subject to ground rent, meaning that they are actually a tenant. They only have an interest in the structure on top of the ground, and they are leasing the ground. So they don't have subsurface rights. They don't own the ground. They only have access to a right and entitlement to the improvement that is on the ground. And so they are leasing, and they pay a lease, a rent to the ground rent holder to continue to utilize the property. And so we can have a whole discussion about ground rents, good, bad, or indifferent, but there is a push in the state of Maryland to extinguish most of them. Another type of interest in real estate that we often see evidenced in deed is that of a life estate, where someone has a right to possess real estate, meaning they have the right to live in real estate for the duration or term of years of someone's life, for a lifespan. It doesn't have to be their lifespan. It could be the lifespan of someone else, but someone has the right to possess real estate for a time period. And after that time period is over, or after that life, the life of whoever's designated in a life estate deed is over, then the real estate automatically transfers to who is listed as a remainder person. And so the real estate deed will list what type of transfer occurs. Is it a ground rent transfer? Is it a transfer in fee simple? So when someone comes to me with a question, it seems like a simple question. Should I add my spouse to the deed? We have to first do an assessment to say, well, can you? What is your ownership? What is your interest in the property? If you want to call in, please feel free to do so. 410-481-1010. Again, that number is 410-481-1010. And so to answer the question, should I add my spouse to a deed? Ultimately, what do you want to happen with the property? Do you want it to go to your spouse? If you want the property to go to your spouse is residing in the property, then the answer may be yes. The reason why it's a maybe, because there is some consideration that needs to occur to whether or not it's wise to add your spouse or any other person to a deed. And some of the consideration first, ultimately, is that the person you want it to go to? And if it is, are you going to do a tenancy by the entirety arrangement? If it is your spouse, if it isn't your spouse, are you going to do a joint tenancy with right of survivorship? Meaning, in both situations, upon your death, the property automatically transfers to that person. Do you not want an automatic transfer of the full right of the property, and you want to only leave that person with a fractional interest? Will you do a tenant in common arrangement? with that spouse or other person? Ultimately, what do you want to happen to the property? Then there's questions we need to ask about the spouse or the other person, if not a spouse, to whom you want to add to the deed. There are several reasons why someone would not want to be added to the deed, or where you should use wisdom in determining whether or not to add a person to the deed. When someone is added to a deed, meaning they're given ownership, a portion or otherwise, the property becomes theirs immediately. So what does that mean? If they have creditors, that property is now subject to his or her creditors. Creditors can include ex-spouses. Creditors can include judgments from lawsuits or lack of payment for consumer goods. A creditor could be a child support enforcement award. You have to know whether or not the person you're adding to the deed is it going to be beneficial to you and them or not? Something to consider. Another thing to consider is whether or not this person whether or not adding them gives this person an asset that may interfere with their right to government entitlements. And so in previous shows, we briefly talked about trust and the benefit of having a trust. And I explained that you remove a person's assets. You remove a person's assets from their ownership, or you don't allow the person to own it. You allow the trust to own assets so that they can have access to government entitlements. So if you have a spouse or someone you're considering adding to the deed that may otherwise be eligible for government entitlements to include Medicaid, which is state funded health insurance. If you have a older individual, someone with special needs, they may be entitled to Medicaid currently, or in the near future, they may need services. However, if you add them to the deed, which gives them title to the asset, which is real estate, you may change, or they may change their eligibility and their income and asset level to qualify for governmental benefits. And Medicaid should be considered if you have a veteran who may be entitled to VA benefits. That's also something to consider. Any entitlement that a person may be able to receive where their income and assets, not just income, but income and assets are included in the equation as to whether or not they would be entitled to service. That is something you need to consider when you are adding someone to the deed, particularly for those who are remarrying at an older age, who may be nearing retirement age, who may be nearing an age where some of these entitlements, they may be eligible for some of these entitlements. So this is why you absolutely have to meet with professionals to make sure that you are making a decision with all of the information. Another thing to consider when adding a person to the deed goes along with creditors. But what is this person's tax liability? What exposure do they currently have? Will adding this asset to their portfolio of assets change the way in which they will be taxed? Will it be a benefit or not? These are things that must be considered. I think that older adults, I got married at 2. So my husband and I, we only had 2 pennies. So putting our 2 pennies together, we felt rich, right? So doing things together at a young age didn't make a difference because we didn't have anything. However, when you have lived a significant amount of life and you have accrued assets over time, and you join your life with that of someone else who has also accrued assets, there needs to be some significant planning prior to marriage so that everyone can understand what things will look like. Love is great. Being married is great for some people, but you have to use wisdom. A lot of people I find when they come to my office, they get in these situations and they add individuals to their deeds, spouse or otherwise, with a lack of understanding. And so I don't just do it. I advise, I counsel, I make sure that all of my clients understand what they're getting into fully before they do it. But I have a lot of people who come to me who make these decisions and they come to me afterwards, and the fix is much harder than making a decision that works for you up front. So consider. You're older in age, you have assets, you get married. Do you add your spouse to the deed? Is a question, again, that requires much counseling. I will say this. There is a misconception, and this was actually another question submitted this morning that I'll address in this episode as well as others. There is a misconception that because you're married, your spouse will automatically inherit everything that you own. Not true. Okay? Not true. Your spouse will inherit based on either what the law says if you pass away without a will, based on what your will says or what your trust agreement says if you have them. So if you own real estate and you don't add your spouse to the deed and you expire, that spouse does not automatically inherit that house. That house must be transferred either by way of your will, by way of your trust, or by way of intestate laws that governs what happens with property when there is no will. Now, ultimately, can the house get to your spouse? Probably so. In some cases, not all, but the spouse will not automatically inherit. And so the one thing that I want you to be clear on, because I have a lot of people that call me who have been through multiple divorces or separations, when it comes to the law, it is not the same for every type of legal matter. So what happens to the disposition with real estate in a divorce or a family law case is not necessarily the same thing that will happen to the disposition of real estate when it comes to estates and trusts. Common people, lay people, just think of the law as the law. But the law is different in very different areas. And so what happens in family law may not happen in estates and trusts, and what happens in estates and trusts may not happen in family law. It depends on the current circumstances, how the property is owned, whether or not an individual is living or deceased. But all in all, no, a spouse does not automatically inherit. Okay. And so remember, in one of the earlier episodes, when we talked about, or when I discussed what happens automatically. So I discussed it with insurance and retirement. Those are contracts. And so if you name a beneficiary absent something going wrong, that I can't even think of an example right now, but absent something going wrong, that retirement benefit or that insurance benefit should go directly to the beneficiary that is named. If that person is a spouse, it will go to a spouse. If that person is not a spouse, it will not go to a spouse. It will go to the person that is named. In the real estate discussion that we've had so far, joint ownership is one way for there to be an automatic transfer. And so that joint ownership, again, could be tenancy by the entirety, or it could be joint tenancy with right of survivorship. Tenants in common is not the type of joint ownership where the whole of the property will pass to the other person. So if you have a tenancy by the entirety or joint tenancy with right of survivorship listed in the deed, which evidences title and ownership of the real estate, then that real estate will automatically pass to whoever is listed as the joint owner. So if your spouse is listed as the joint owner and the only joint owner, and you predecease your spouse, you pass away first, then yes, the property will pass to the spouse. But if you have a child listed as joint owner, without regard to you being married, if your adult child or minor child is listed as a joint owner, then the real estate will pass to the joint owner, not your spouse. And so it's very important with all of the assets that you have that we are clear on how you own it. And is there a contractual or an operation by law, an operative event that requires that the property automatically pass to either a named beneficiary or another owner? If those things aren't in place, then and you are the sole owner of property, and in this case, real estate, that property will have to pass according to your estate planning document. That document could be a will. So if you're married, but you had a will done prior to marriage, and in your will, you pass your real estate to your adult children, guess what's going to happen? When that will goes through probate court, your spouse, although living in the home, will not inherit that home. The adult children who are specified in your last will and testament are the people or a person who will inherit that home. So it's very important if you are older, you get married, not even older, if you get married after acquiring assets that is solely titled to your name, you need to sit down with a professional on your own. Bring your soon-to-be spouse into the conversation and have discussions about what you want to happen to the property. Do you want it to pass to your spouse or not? Because it doesn't have to. And if you do want it to pass to your spouse, what are the easiest ways to do it? And does it make sense to do so? Does it make sense to add your spouse as a joint tenant? Do they have creditors? Do they owe back child support? Are there these things that you need to be concerned about when adding as a joint tenant? And so we can discuss and have conversations whether or not it would be better to put the real estate in trust for the benefit of your surviving spouse and your adult children. But ultimately, when you have real estate, you have to be aware of how do you own it? What specifically do you own? If you get married or you're doing life and partnering with someone, whether or not you want to share that ownership. You need to understand whether or not family law applies to you if you decide to not be with that person before your expiration. What does divorce or separation look like for you if you have joint ownership? And should you predecease that person and you do want it to pass to them, what ways in which are you going to do it? Or do you want them to share in ownership? So there are tons of things to consider when you ask, should I add my spouse to the deed of my home? So I hope this has been helpful. I'm going to encourage you again, please go to sherryfleming.com/Our Legacy Matters. Submit your questions so we can answer them on air. Thank you for joining me today, and I look forward to connecting with you next week. Thanks for listening to the Our Legacy Matters show. Connect with me, Attorney Sherry Fleming, at I Am Sherry Fleming on all social media platforms or at sherryfleming.com/Our Legacy Matters, or you can call us at 410-316-6800. Make sure you tune in next week for another discussion because our legacy matters.
The new 1010 WOLB with talk in the day and soul at night.